Good morning, students. Today is Monday, 28 February 2022. This recorded lecture will be the lecture for Tuesday's class. That's tomorrow. Remember what I told you in my email the other day? I told you that from now on, for the rest of the semester, I will provide you both a lecture and a discussion. The lecture will be recorded and posted on Canvas, and I'll try to do that every Monday and Wednesday. On Tuesdays and Thursdays, I will be in the classroom, and if anybody shows up, we will have a discussion. I won't redo the lecture since that will have been done already. If you want to come to class tomorrow at 8 o'clock, remember the class period is from 8 until 9:20. If you want to come, make sure you have a few questions written down about this case that we're discussing, and I'll try to answer them. So we'll have a brief discussion. If you have lots of questions, we'll continue. We'll stay the whole period. So you're getting your lecture and something in addition to that, which is a discussion. I will continue to post my lecture notes for the rest of the semester. I assume you've been using those to follow along. Today, for example, I'm going to pick up on page 7 of my lecture notes for this case, Cohen versus California. So that's the plan for the rest of the semester. Let's see, today we're going to finish up this case, Cohen versus California, and that means for the second lecture this week, I will have to post the reading and my lecture notes, and I'll get the first lecture posted on Canvas on Wednesday. And that means Thursday this week, we will meet in the classroom, at least those of you who want to come, and we'll have a discussion about the first third of that article. Okay, I don't think there's anything new on Canvas. I've posted everything that I plan to post on this case. Make sure you look it over. If it says optional reading, of course, you can choose not to read it if you'd like. So let's pick up on page 7 of my lecture notes, where it says Justice Harlan's majority opinion. Now it's the majority opinion because at least 5 of the 9 justices signed on to it. And those 5 are Harlan, Douglas, Brennan, Stewart, and Marshall. So those 5 formed the majority, and Justice Harlan wrote the opinion. Now, don't confuse John Marshall Harlan, who is the author of this opinion, with another John Marshall Harlan, who coincidentally also served on the Supreme Court. And in case you're wondering, yes, they are related, not father and son, but grandfather and grandson. So if you turn to page 8, I did a little bit of research for you, and I'd like you to keep the following justices clear and distinct in your mind. First of all, one of the first Supreme Court justices, not the first, but one of the earliest, was a great jurist called John Marshall. And you can see on my diagram that he was Justice of the Supreme Court. In fact, I believe he was Chief Justice for this whole period, from 1801 to 1835, a period of 34 years. And I put his birth and death dates on there as well. Now, John Marshall Harlan, the grandfather of the author of this opinion, Cohen, John Marshall Harlan was born in 1833, and he served on the court for 34 years as well, from 1877 to 1911. Now, John Marshall Harlan, so far as I know, is not related to John Marshall. He may have been named after him, though. I didn't look into that, or at least if I did, I didn't find anything. So it may be that John Marshall Harlan's parents named him after the great Chief Justice John Marshall. At any rate, sometime later, John Marshall Harlan, the grandson, was named to the Supreme Court, and he served from 1955 until 1971. So his term on the court was shorter. It was only, 16 years. The father of John Marshall Harlan did not serve on the court. So it was the grandfather and then grandson. And all three of these justices are considered among the very best that the court has ever had. Their opinions are well written and carefully reasoned, and many of them stand today. They have not been overruled. Okay, so keep those names clear in your mind. I'm not going to ask questions on the exam about it, but just for your own purposes. Now, it's sad, but this case that we're discussing, Cohen versus California, it was decided in June of 1971, and it was only 6 months later that John Marshall Harlan died. He died half a year after this case was decided. Okay? Now, I've told you that, as a kind of a sidebar to this case, the opinion is credited to Justice Harlan, but it was not written by him. It was approved by him, and it's published under his name, but he had one of his law clerks write it, and that law clerk, we now know, was Thomas Crattenmaker. He may still be alive. He's an old man now. He had a distinguished career in the law as a professor and a litigator, as a lawyer. He says in his article that I posted on Canvas that he was asked by Justice Harlan to write this opinion, or at least a draft. He gave the opinion to Justice Harlan, and he says that Justice Harlan made only 2 minor changes to it, which is pretty amazing. So almost every word that you read in here was written by Crattenmaker, who was not a justice of the Supreme Court, not a judge at all. In fact, he was pretty fresh out of law school when he wrote it. So that's a real feather in his cap. And he wrote a law review article describing the case and how his opinion came about. And again, I posted that on Canvas if you'd like to read it. Okay, so let's get started. Let's start analyzing and evaluating the majority opinion. Later, at the end of our discussion today, we'll look at the dissenting opinion and see what they have to say. Now, the introduction of the introduction of the case goes as follows. This case may seem at first blush too inconsequential to find its way into our books, but the issue it presents is of no small constitutional significance. So that's the first sentence. It's on page 15, the first page of the article of the case. So why would Justice Harlan, why would he say that this case at first blush seems too inconsequential to find its way into the books? Well, it may be because of the content of the case. It has to do, after all, with the phrase F the draft. And someone might think that that doesn't really rise to the level of a constitutional case decided by the Supreme Court. But I think what Justice Harlan is saying is that even though the words that were involved in this case may be trite or insignificant, the issue that is raised by this case is very important. It has to do with the freedom to speak. It has to do with whether the freedom to speak includes speech that is offensive to many people. So it's an important case about the scope and limits of the First Amendment right to speak or to express oneself. Now remember that the First Amendment was incorporated by the 14th Amendment. So it is now applicable to all of the states and their subdivisions, as well as to the federal government. So the next thing that Justice Harlan does, now I'm going to keep acting as though Justice Harlan wrote the opinion. And in a way he did, because he approved what he was given by his clerk, Thomas Crattenmaker. So by signing on to it, he in effect adopted it as his own. And by the way, I'm not implying that there's something unusual about this. I think most Supreme Court justices do ask their clerks to write drafts. And once the draft opinion is given back to the justice can do a number of things. The justice can read it over and approve it almost in its entirety, as happened here, or The justice might disapprove of some of it and make notes on it, telling the clerk to go back and do some more research, omit this argument. There may be a big X through a paragraph. The justice will typically interact with his or her law clerk. And eventually, through this interaction, this back and forth, eventually the opinion will be finished and approved by the justice. So the only oddity here is that so much of the draft opinion was approved by Harlan. And that's either because Krattenmaker is a good writer and a good attorney, and he did a good job. He did it so well that Justice Harlan didn't feel any need to make many changes. Or perhaps Justice Harlan was lazy. That's a possibility. Maybe he didn't feel like going through it carefully and making changes. Now, I'm not suggesting that he was lazy, but that would be an explanation for why he made so few changes to it. But I prefer to think that Krattenmaker did a bang-up job and that Justice Harlan was impressed and simply didn't have much else to say. Okay, what are some of the matters that are not presented by this case? This case raises an important issue that needs to get resolved. What issues do not need to be resolved in this case? What matters do not even need to be addressed on their merits? And I have a list, a bulleted list of points, which I've taken from the opinion. First of all, notice that Cohen was arrested for his speech, not for his conduct. It's not because of anything he did, like punching somebody or running in the corridor of the courthouse. Those would be actions, and they could be punished, surely. Cohen was not arrested for anything he did. He was arrested for what he said. Now, when you say things, strictly speaking, you're doing something. I'm doing something right now, namely speaking. So every time we speak, we're performing an action. So when I say that Cohen was arrested for his speech and not for his conduct, I mean, he wasn't arrested because of any bodily movements, like punching someone or running or throwing something. He was arrested because of what he said, not because of what he did. Now, what if he had written, instead of writing F the draft on the back of his jacket, what if he had written, have a nice day, or support the draft on his jacket? What if he had written something like that? He surely would not even have been arrested. Nobody would have arrested him. There would have been no trial. There would have been no conviction, and there would have been no sentence. And therefore, there would have been no appeal. Right? So no arrest, nothing would have happened beyond that point. So clearly, it's because of what he wrote on his jacket that he was arrested, not the fact that there was something written on his jacket. So this is an important point because conduct, at least nonverbal conduct, conduct that's not speech or in words, conduct is always regulable by the state. What I mean by regulable is capable of being regulated, even prohibited. So this case does involve speech, and you can see that because if he had said something other than F the draft, this case would not even have occurred. Secondly, you now know that the Supreme Court allows regulations of speech for purposes of time, place, and manner. A reasonable regulation of speech designed to limit the time at which speech occurs or the place at which it occurs, like a street or a park or something, and the manner in which you speak, whether it's done with a bullhorn or blaring sirens, things like that. So the manner, the time, and the place may be regulated. This case is not about that, according to Justice Harlan. Why? Well, if you read the statute applies throughout the state of California. It's not limited to courthouses. If it were limited to courthouses, you could make a case that it's simply a regulation of the place of speech. But this statute covers not only speech in a courthouse corridor, but speech anywhere in the state, anywhere, in any public place, presumably even in a private place. So this case cannot be brought underneath the time, place, and manner exception, where the state is allowed to regulate or prohibit. Third, according to the court, there is no category. This case does not fall within one of the unprotected categories of speech. You know what I'm talking about? Some speech, it falls into a category that the court has recognized as being unprotected, or, if you will, low value speech. And we see many examples of that in my most recent lecture. Obscene speech, true threats, child pornography, fighting words, incitement, and so on. Remember that list we went over thoroughly a few days ago? According to the court, according to the majority, this case does not fall within any of those categories, which means it's protected speech, which means that Cohen could not have and should not have been convicted as he was. Let's run through some of those categories so you can see why this case doesn't fall within them. This is not an obscenity case. Now, yes, it involves that F word. And that F word is sometimes used in a sexual way. It's used to describe a particular act of sexual intercourse. And you can fill in the details from there. But in the law, the word obscenity refers to erotic conduct, right? A book is said to be obscene when it depicts erotic behavior or erotic scenes of some sort. The same with a movie or a play. To be obscene for legal purposes, the material in question must appeal to the prurient interest in sex. And that was not the case here. Cohen did use the F word, but not in a sexual or erotic way. That F word is versatile. It's ambiguous. It has many meanings and many uses. So F the draft means something like down with the draft. And that, of course, has nothing to do with sex or eroticism. So the first thing the majority, remember, Justice Harlan wrote this opinion. He was the author, but he was not the only justice who signed on to it. There were 5. So I'm going to refer to the majority opinion from time to time, and you know what I'm talking about now. So this is not an obscenity case. It does not fall within that category. If it were an obscenity case, then the state of California could rightly regulate it or even prohibit it, but it doesn't fall in that category. This is not a fighting words case. Remember the case of Shaplinsky versus New Hampshire? We didn't discuss it in detail, but I did cite it when we discussed the fighting words doctrine. The fighting words doctrine is designed to prevent people from starting fights by getting up into people's faces. It requires close physical proximity. And the idea is that if you say something insulting or disparaging to someone in a way that is calculated to or intended to create a disturbance or a fight, your speech may be prohibited and punished. According to the court, the majority, this is not a fighting words case because there was no direct personal insult. Cohen did not, according to the facts of the case, so far as we know them, Cohen did not walk up to someone, such as a security guard, and turn his back and put his back into the face of the security guard, as if to insult the security guard with that expression, F the draft. So there was nothing like fighting words involved in this case. Right? There was nothing insulting about it. No interpersonal insult, which is what the fighting words doctrine requires. Now, I'm not saying that nobody was insulted or offended by it, but it lacked that interpersonal element. that is essential to the fighting words doctrine. Next, this is not an incitement case. Incitement is when you use language to incite people who are there present with you to commit a crime. It's when, for example, someone is on a soapbox out in public with a crowd gathered round. The crowd is all upset or angry or agitated about something, and the speaker says, pointing, let's say, to a house nearby, let's go kill or injure the inhabitant of that house, or let's go burn that house down. That would be incitement. You are trying to rile up the crowd and get the people in that crowd to commit a crime. Right? That's different from fighting words. Do you see the difference? The goal of the inciter is to get other people to commit a crime. And the court has ruled in many cases that can be prohibited and punished, provided that the intention of the speaker was to incite a crowd or an individual to break the law, and there was a strong likelihood that would occur. And that part is put in there because it may be that the incitement was clearly a joke or not meant to be taken seriously. And so at the time of the utterance, there wouldn't have been a likelihood that people would follow through and actually break the law. So it has to be an intent to incite people, and the law breaking must be likely to occur as a result of that inciting speech. So according to the majority in this case, Cohen was not trying to incite anybody to break the law. It's a case that does not fall under the Brandenburg case that I mentioned the other day. Okay, third, this is not a captive audience case. Now, I haven't said anything about this yet, but the court has ruled that it matters in terms of whether speech may be prohibited and punished. It matters whether the audience for the speech is captive or not. And by captive, I mean the audience can't get away from it. The audience can't turn around and leave or avert their eyes or ears. The audience is captive and is exposed to the speech whether the audience wants to hear it or not. The court said this is not a captive audience case. The reason Cohen was arrested is not that he was doing things in a courthouse where no one could get away from it. In fact, this statute in question applies to all kinds of situations, and it makes no reference to a captive audience. The statute in this case in California did not say it's illegal to speak in an offensive way to an audience that can't get away from your speech. It says nothing about that. So this case cannot be dismissed as falling under the captive audience doctrine. In fact, here's what the court says on page 21. Those in the Los Angeles courthouse could effectively avoid further bombardment of their sensibilities simply by averting their eyes. So if someone in the courthouse corridor had happened to see Cohen walk by and noticed what he had written on the back of his jacket, if that person was offended by it, that person could simply avert his or her eyes and not see it again. So the offense would be momentary, and from that point forward, it's within the person's control as to whether to continue looking at it. The same is true if someone goes into a bookstore. If you go into a bookstore and you're browsing the shelves, you open up a book wondering what's in it, you may find some images in the book that are offensive to you. If so, close the book, put it back on the shelf, and go elsewhere. You could leave the bookstore altogether, go to a different section of the bookstore, and get away from that offensive material, or stay in the same section but look at other books, hoping you don't see any more offensive material. So the law does take into account how easy it is, how reasonable it is to expect people to avoid being offended. And on this question of the statute and its wording, here's what the court says on page 22. And I'm reading from my notes, page 8. The statute in question, quote, evinces or shows no concern with the special plight of the captive auditor. Auditor is a hearer. But instead, indiscriminately sweeps within its prohibitions all offensive conduct that disturbs any neighborhood or person. So you can't with a straight face argue that this case involves a captive audience. It can't, because the statute in question ranges far more widely than that. It covers not only captive audiences, but non-captive audiences. So the statute on its face, it cannot be construed as being designed to protect people who are captive to other people's speech. Okay, next point. This is not a symbolic speech case, like burning a draft card or burning a flag. We talked about this the other day. You can, sometimes you can express yourself, ideas, or emotions without uttering any words, by burning a flag on a courthouse step, for example, or burning a draft card in public. The court has ruled, or wearing a black armband or some kind of armband. The court has ruled that that is protected speech. Now, is that the case here? Is there any kind of symbolic speech here that needs to be protected? Well, the court says no. What Cohen did was not symbolically saying something, he said it in words. This is a verbal speech case, not a symbolic speech case. Now, keep in mind that if the court had ruled that this was symbolic speech, the court may well have ruled that it's protected, because the court has done that in other cases, like flag burning. All I'm saying is that this case doesn't even fall under the heading of symbolic speech. It's quite clearly speech in words. F, the draft, is 3 words, a 3-word statement that is being expressed by Cohen. It happens to be on his jacket, but it could have been written on a placard or a flyer. It could have been spoken. He could have said orally, F the draft. So the court simply disposes of this whole issue. It's not symbolic speech. We have to analyze this case in terms of verbal speech, and we have to see whether it's protected. Okay, so those are some of the matters that are not involved in this case, just to clarify that. Now, you may notice in my lecture notes I have an acronym, IRAC. Every law student learns this right away as soon as he or she starts law school. IRAC stands for issue, rule, application, conclusion. Sometimes the word application is replaced by analysis. So here's the procedure that you should use whenever you read a judicial case, a legal case like this. Try to identify the issue. What's the case about? Once you identify the issue, try to identify the rule that the majority used to resolve that issue. The rule could be a constitutional provision. The rule could be a statute, such as it is here. The rule could be a previously decided case or cases in the same jurisdiction or in a higher court, a higher jurisdiction. It could be a regulation from a governmental agency, and so on. First, try to find the rule that the court used to resolve the issue. Once you identify the rule, you should pay attention to how the court applies that rule. Applies it to what? Well, the court will apply the rule to the facts of the case. And you know the facts of this case pretty well by now. So once the court decides what the rule is, the court will apply that rule to the facts and reach a conclusion. It's reasoning. You could think of the rule as the major premise of the argument. The facts of the case constitute the minor premise, and the conclusion is the conclusion of the argument. So judicial opinions, or what Orrin Kerr called legal opinions, they are really arguments or justifications by the court of its decision, of its ruling. Remember the term ratio decidendi? That's the rationale for the decision. The rationale is the supporting argument. So we know the issue in this case, but let's state it clearly. It's at the bottom of my page 8 and again on the top of page 9. Here's how Justice Harlan and the majority frame the issue. Quote, whether California, and I put in brackets, not just California, but any other state or political subdivision of a state, such as a city, a county, a township. Whether California can excise, now excise means cut out, whether California can excise as offensive conduct one particular scurrilous epithet, and you know what that is, it's the F word, from the public discourse, either upon the theory of the court below, that would be the trial court, that its use is inherently likely to cause violent reaction, or upon a more general assertion that the states, acting as guardians of public morality, may properly remove this offensive word from the public vocabulary. So the issue in this case is whether California or any other state can take a word or phrase or sentence out of circulation by prohibiting it and punishing it, either because it's considered to be offensive or because it's considered to be immoral. Okay, those are two different ways the state might try to justify prohibiting or punishing a word or phrase, either because it's offensive to others or because it's inherently immoral, inherently wrong. Now that's the issue as the court states it. If you want to put it in a simpler way, and I do here in my notes on page 9, the issue, in other words, is whether the statute is unconstitutional. Does this California statute comply or comport with the Constitution of the United States, or doesn't it? That's what the court has to decide. Is this statute allowable by our Constitution? Remember, the court has the power of judicial review. That means the court can review or examine or scrutinize acts of government, such as statutes, and decide whether they are allowable under the Constitution. The Constitution of the United States is the supreme law of the land, and anything that is contrary to it cannot be allowed to stand. Any statute that is contrary to the Constitution must be struck down and ruled to be unconstitutional. And that's the issue the court has to decide here. In a way, the court has the statute of the statute of California right here, and it has the Constitution here. The court has to decide whether those two are compatible with one another. And maybe they're not. The court ruled that they're not. Right? We can't have both the Constitution, specifically the First and 14th Amendments, and this statute. So something's got to go. They cannot both stand. Well, if a Constitution clashes with a statute, which one has to go? Obviously, the statute has to go. And that's because the Constitution is the supreme law of the land. So that's the issue. Now, what's the court's resolution? What's the rule that the court applied? The rule applied by the court is that speech is to be allowed under the Constitution unless it falls within one or more of those categories that we've been discussing, a category of unprotected speech. So think of it this way. The rule is that there's a presumption, maybe even a strong presumption, in favor of speech. The mere fact that a particular act is an act of speaking or writing gives it a certain prima facie protection under the law, under the Constitution. But of course, presumptions can be rebutted. And you would rebut this presumption by showing that the speech in question falls within one or more of those categories that we've discussed, such as obscenity, because those are categories of unprotected speech. So Cohen has a presumption in his favor. You see that? The presumption is that what Cohen said is allowable, is protected speech, unless the prosecution can show that it falls within one of the categories. So that's the rule that the court applied. What is the application of the rule? And what's the conclusion? Well, look under my section entitled Resolution, and you'll see. The court ruled that the statute is unconstitutional. That means it's contrary to the Constitution. It violates the 14th Amendment. Remember, the 14th Amendment has been held by the court to incorporate the First Amendment right to liberty of expression or freedom of expression. So I'm going to talk about the 14th Amendment because we know that the First Amendment is incorporated in it, at least the free expression part. In fact, all of the parts we know have been incorporated. All of the clauses of the First Amendment have been incorporated by the 14th Amendment and made applicable to the states. So the court ruled that Cohen prevails. Cohen's speech, however offensive it may have been to however many people, Cohen's speech, however immoral it may be in and of itself or to people, is protected. We have a right to say things that offend others. We have a right to say things that are immoral by certain people's lights. So in the remainder of its opinion, the court is going to address some counter-arguments and reply to them. Have you ever heard the term heckler's veto? Let me give an example. Recently, in recent years, people have been invited to college campuses to give talks or engage in debates. Some of these speakers are unpopular with certain segments of the university community, students, professors, staff, and so forth. Some student groups, knowing that a particular speaker will be on campus, announce that they are going to disrupt the speech or the debate. They make it known that others who disagree with the speaker should come out and they will heckle the speech, perhaps in such a way that nobody who wants to hear the speech can hear it. Now, what if the university, knowing that this sort of heckling will occur, what if the university, and might cause disruptive behavior, it might cause violent acts or property damage for all concerned, for the speaker, for other people who happen to be on the stage, like a moderator, for the audience members, bystanders. What if the university, concerned about a violent spectacle, cancels the speech? Then you could say that the hecklers, the would-be hecklers won. They got what they wanted. They didn't want the speaker to be heard. They didn't want the speaker even to speak. And in order to prevent that, they announced that they're going to be disruptive. So disruptive that the university takes preemptive action to cancel the speech. So the hecklers got what they wanted. This is called the heckler's veto. The hecklers decide what may and may not be said on that campus. Which speech may and may not be allowed to occur or take place. Now, there seems something deeply wrong with that. Why should hecklers get to decide what speech is offered on a college campus or really any other place? What if a large number of people want to hear the debate or want to hear what the speaker has to say? Not necessarily because they agree with it, but because they like to see all sides of an issue. Maybe maybe they're dead set against the speaker, but they still want to hear the argument made by the speaker. I want to see a powerful case made for a conclusion that I happen to disagree with. Why should the heckler get to decide that the speaker can't speak and the audience members can't hear it? So here's what the court says about the so-called heckler's veto. Quote, this is from page 23, quote, "The argument amounts to little more than the self-defeating proposition that to avoid physical censorship of one who has not sought to provoke such a response by a hypothetical coterie or group of the violent and lawless, the states may appropriately effectuate that censorship themselves." So the argument is that the state can intervene and prevent and punish speech in order to prevent a violent response to that speech by hecklers and other antagonistic people. You'll notice I put in my notes, compare what is happening on certain college campuses. Speeches have been canceled because of threats of violence. So the court is not impressed by this argument at all. In fact, the court seems determined not to let the hecklers have a veto. We're not going to let the state of California prevent people from speaking just because someone might protest or engage in disruptive or unruly or even violent conduct. So people have a right, the court seems to be saying, people have a right to speak even when there's a good chance that it will be met with opposition and protests and even a chance of violence or property damage. So here's how the court formulates the rule. A moment ago, I gave you a short version of the rule. The court says on page 24, governmental bodies may not prescribe the form or content of individual expression. Now, that's about as close as you'll get to a statement of the rule that the court used. Think of it as a rebuttable presumption in favor of speech. The court is saying that unless it can be shown that speech clearly falls within one of the unprotected categories, it is allowable by law. People have a right to say it or write it. Okay, now let's move on to the next point. One of the famous phrases that emerged from this case, written by Krattenmaker, the law clerk, is powerful medicine. So let's read this longish quotation from page 24. And I think this can be understood as the court's statement of the rationale for the rule. Here's why we have a presumption in favor of speech. Remember, that's the rule. The constitutional right of free expression is powerful medicine in a society as diverse and populous as ours. It is designed and intended to remove governmental restraints from the arena of public discussion, putting the decision as to what views shall be voiced largely into the hands of each of us, in the hope that use of such freedom will ultimately produce a more capable citizenry and more perfect polity and a more perfect polity, and in the belief that no other approach would comport with the premise of individual dignity and choice upon which our political system rests, unquote. That's interesting because you can see in the two parts that I italicized, I did the italicizing, the court is stating two different types of rationale for the rule, the presumption in favor of speech. The first is that it will have good consequences in the long run, on the whole. What are those good consequences? Well, if people are free to speak their minds, to make a case for whatever conclusion they happen to believe, people will be exposed to a wide range of views and values, and they will be able to sift through them and get the truth, if that's what they're seeking. Right? Truth will emerge in the long run from a clash of ideas. This is sometimes called the marketplace of ideas. Out in the marketplace, it's kind of a wild and woolly place. Right? There are insurance companies selling, many different insurance companies selling health insurance. And if you need health insurance, you need to go out into that marketplace and listen to the sales pitches of each of these firms that's offering health insurance. Now, each health insurance company can offer whatever types of insurance it wants with whatever deductibles, co-pays, and premiums, and so on. They will try to persuade you to purchase their own product rather than some competitor's product. And it's up to the consumer to listen to all these competitive claims and make a decision. Well, there's also a marketplace in ideas, right? If you go out into the public square, so to speak, you find just about every view being supported, defended, criticized, analyzed. And a citizen can and should go out into public, listen to all the views, and make up his or her own mind about what the truth is. That's what you do in an economic marketplace, right? The same idea. So the court is saying that in the long run, we're all better off if we allow a vigorous marketplace of ideas. Right? We all benefit from that. The truth is more likely to emerge in a marketplace like that than it would if we allowed the state to try to determine in advance which views may be expressed and which not. Right? That would limit our options. People might not even hear about communist ideas or socialist ideas or anarchistic ideas or libertarian ideas. We should be able to hear all these ideas expressed in public. Right? We should hear proponents of every one of these political ideologies. We should be able to hear different religions expressing their doctrines, and so on. Okay? A robust and lively marketplace of ideas. In the long run, the court seems to be saying that will work to the benefit of all of us. We'll be more likely to form true beliefs in that situation than we would in some other alternative situation. So the first rationale for the presumption in favor of speech has to do with the consequences of allowing speech to be free and not restricting it. The second rationale is quite different. The court, notice, says that no other approach besides freedom would comport with the premise of individual dignity and choice. So the idea here is not so much that the consequences of free speech will be better than a regime of stifling speech, but it's more respectful of the person. Each of us is quite capable, each of us who's an adult, a competent, autonomous adult, each of us is capable of listening to or reading the views of others on every topic. Each of us is capable of sifting through them and deciding which of them are true and which false, right? And the state allows people the dignity to choose by trusting them to sift through these competing views and decide which is true and which are false. So it respects the dignity of each citizen to allow them to be confronted with views that they may find offensive or believe to be immoral. But in a free society of autonomous individuals, we have to put up with some degree of offense. We have to develop a thick skin, or so the argument goes. Okay? So the court's rationale for this rule, this presumption in favor of free expression, it seems to have two different justifications or rationales. One of them is forward-looking. It says the consequences will be better if we adopt this approach than they would if we adopted some alternative approach. And the other one focuses on not so much the past, but the present. It says that if you respect people's dignity, you will allow them to make up their own mind. after listening to all the views being expressed in the public square. That's the only doctrine or rule that is respectful of the person, that respects people's dignity and autonomy. Okay, now let's look at some individualized considerations or particularized considerations that support reversal, that support reversing Cohen's conviction and sentence. First of all, the court seems to be concerned with what's called a slippery slope. Now, before we go any further with this, I want to explain the meaning of that term very briefly. You may have heard the term slippery slope. You may have heard of a slippery slope argument, or perhaps you've heard of a slippery slope fallacy. So let me explain, first of all, the concept of a slippery slope argument. A slippery slope argument goes like this. The arguer begins by pointing out that if we do a particular thing, certain consequences will occur, invariably. If we do X, Y is bound to occur. It's as though by doing X, we are going to set in motion a chain of events that will culminate in Y occurring. The second premise of the slippery slope argument says that Y is bad. In other words, we don't want to end up in that situation because it's bad, maybe very bad, maybe horrible. Now, what do you get when you put those two premises together? Premise one says, if we do X, then we'll end up in situation Y. The second premise says, and Y is very bad, maybe horrible. The conclusion, as you can probably see, is that we shouldn't do X. We shouldn't do X because if we do, we're going to end up in a very bad place. And presumably, we don't want to end up in that very bad place. So reasoning backward, we decide we shouldn't do Act X. This is called slippery slope reasoning, or a slippery slope argument. Now, listen carefully to what I'm about to say. Not all slippery slope arguments are bad arguments. They're not all fallacious. A particular slippery slope argument could be a good argument. It would be a good argument if the premises are true. In other words, suppose it's true that if we do X, we will almost certainly end up in Y. And suppose Y really is a bad place to be, a place we don't want to be. Well, then we would be well advised not to do X. That would be a good argument. Right? If the premises are true in this situation, then the conclusion would be true as well. And that says we shouldn't do X. Now, the reason we have a term slippery slope fallacy is because a great many of these slippery slope arguments are bad arguments. They're so bad that we call them fallacies. Now, what distinguishes the good slippery slope arguments from the bad ones? Well, there are two ways a slippery slope argument could go bad. First of all, the first premise might be false, or it may be unreasonable to believe it or accept it. Sometimes an arguer claims that if we do X, we're bound to end up at Y. But that could be false. Maybe we can do X and not end up at Y. Maybe there are safeguards that we can put into place. We do X, but at the same time that we do X, we implement safeguards. We set up some safeguards so that we won't end up at Y. Okay? So that would be a way of showing that the first premise of the argument is false. It's false that if we do X, we're bound to end up at Y. We're not bound. There are things we can do to prevent that from happening. So that's one way to oppose a slippery slope argument and to claim that it's fallacious. It's to show that the first premise is false. The other way is to show that the second premise is false. The arguer claims that Y is a bad place to be. Well, you might disagree. You might say, no, actually, Y is okay. I'm willing to accept it. So let me give an example of a slippery slope argument, and you can determine for yourself whether it's fallacious. It's often argued that if we allow Congress to ban, let's say, certain types of bullet, what are called cop killer bullets, these are bullets that are designed to pierce body armor, to go through bulletproof vests. The argument is, if we allow Congress to ban or prohibit cop killer bullets, then that will embolden Congress to pass other legislation, and the end result of that process will be Congress banning the possession of firearms by individuals. Okay? So the first premise of this argument says, if we allow Congress to ban cop killer bullets, then it's only a matter of time before Congress will be banning the individual ownership and possession of firearms. The second premise of the argument is that that's a bad place to be. It would be bad if Congress banned individual ownership or possession of firearms. Therefore, according to the arguer, we shouldn't let Congress ban cop killer bullets. That would be the first step on a slippery slope. And we don't want to slide all the way down to that bad place. Now, is everyone going to accept the second premise of that argument? The arguer says it's bad if Congress took away everyone's guns. Someone might say, no, I don't think that is bad. I'd be happy with that. There are people, as you probably know, who would love to live in a society such that allows no private ownership or possession of firearms. Some people think that would be a terrific, a good society, maybe an ideal society, right? There would be far fewer murders than there are. There wouldn't be zero because there are other ways to murder besides shooting, but the number of deaths by murder would decrease significantly. And many people would think that that is such a good result that anything that makes that result more likely is justifiable, such as banning individual ownership or possession of firearms. So my point is, when someone makes a slippery slope argument, it's always open to a critic to say the first premise of that argument is false, and let me explain why, or the second premise is false. I don't think it is a bad place to be. I think it's a good place or acceptable place to be. So only those arguments that have a false premise are the fallacious ones. So what if on the exam I said, true or false? All slippery slope arguments are slippery slope fallacies. True or false? I hope you know now it's false. Not all slippery slope arguments are fallacious. Some of them are good because the premises are true or justifiable. What if I turned it around? What if I said, true or false? All slippery slope fallacies are slippery slope arguments. That's true, isn't it? That one's true. Compare all dogs are animals, which is true, with all animals are dogs, which is false. Okay, so that's what a slippery slope argument is, and that's how you go about evaluating a slippery slope argument. Here's what troubles the court. The court, the majority anyway, is worried that if they allow states like California to prohibit and punish the utterance of words like the F word in public, states will become emboldened to ban other words. And the end result of that process will be to so restrict what people can say that our language will be forced to be very bland. We will have to say, maybe we can't even say darn it anymore, or heck, right? First, we're going to ban the word hell, and then someone's going to say, yeah, but heck is used in the same way that hell was, so we're going to have to ban heck too. So people won't be able to say, heck with it. And if they do and are observed, they can be arrested and tried. Do we really want that? Do we want to embolden states like California to go even further than banning the use of the F word? Here are some other words that might conceivably be banned if we allow banishment of the F word. The word screw. Someone like Cohen might wear a jacket that says screw the draft. And that might offend people as much as F the draft. And so an argument could be made that if we don't allow F the draft, we shouldn't allow screw the draft either. What about the word hell, as in to hell with the draft? Cohen might have written that on his jacket, to hell with the draft. What about the word sucks? The draft sucks. You hear that word in public. I hear it on TV. People saying, prime time, oh, that sucks. That's a word that's fairly common now in our society. Mightn't a state at some point ban the use of that word and say that it's prohibited and punishable? Here's what the court says on page 25. Surely the state has no right to cleanse public debate to the point where it is grammatically palatable to the most squeamish among us. Yet no readily ascertainable general principle exists for stopping short of that result, were we to affirm the judgment below. No general principle exists for stopping short of that result. The court is making a slippery slope argument. The court is saying, premise one, if we, the court, allow states like California to prohibit and punish use of the word F, the F word, then states will inevitably ban other words, perhaps screw, hell, sucks, and words like that. And pretty soon, all manner of words that might offend someone will be banned and punished. The use of them will be punished. The second premise says we don't want to live in a society like that, a society of prudes or Puritans, squeamish people who, upon hearing or seeing a certain word, shake in terror or shudder or get physically ill or get frightened. Some people, there's actually a word for this, logophobia. Look it up. It means fear or dread of certain words. We have a word for the fear of words. It's logophobia. There's also a word, onomatophobia, and it's fear of the sound or sight of a word. So we have two words in our language, logophobia, onomatophobia. You can look them up. That have to do with people's negative reactions to the use, the sight or sound of certain words. And that's concerning. I mean, I hate that word concerning, and I find myself using it as in a moment ago. That's a matter of concern to the court. Right? Do we really want to start a process whereby states try to cleanse the language of offensive words? And the court's implicit answer is no, we do not. Once again, here's the court's argument. First premise, if we allow states to ban the F word, then it's only a matter of time before they will be banning lots of other words. Second premise, we don't want to get to that point where we've in effect given the squeamish a veto over what other people may say. Therefore, we should not allow California or any other state to prohibit the use of the F word. So the court's making a slippery slope argument. I'll leave it to you whether this argument is one of the fallacious ones or one of the good ones. But it's clearly a slippery slope argument. I think that much is clear. Different people might evaluate it differently. In case you're wondering what my view is, that's not really important. whether I think that is a good argument or not. I'd want to think about it some more, to be honest with you. But it is a slippery slope argument. The court used the famous phrase, "One man's vulgarity is another's lyric." And I think that's from the opinion. Let me make sure. I have it quoted in my notes, which suggests that it's in the opinion. Yes, it is. I'm looking at page 25, down here, near the bottom, and it says, while the particular four-letter word being litigated here is perhaps more distasteful than most others of its genre, like screw the draft, it is nevertheless often true that one man's vulgarity is another's lyric. So the court seems to be saying that to certain people, the F word is vulgar and offensive. Other people may not only not find it vulgar or offensive, but they may find it lyrical. It's a beautiful word. They love to hear it. It's a word with a mystical power to it. That F word, as you know, can be used as a noun, a verb, an adjective, an adverb. I mean, whole articles and books have been written about that word. In fact, there's a long article written by a law professor, Christopher Fairman, which you can look up. Go to Google Scholar and type in the author's name, Christopher Fairman, Fairman. And the title of his article is The F Word, spelled out, F-U-C-K. That's the title of his article. And I've actually taught it in this philosophy of law course at least once. I don't do it now. No particular reason. I thought I would simply discuss Cohen rather than that law review article. I didn't want to do both, so I picked one or the other. But you can find it and read it if you'd like. It's about all the many uses of the F word. It's about the Cohen case and many other legal opinions in which that word was involved and so on. So there are people, rap artists, not just rap artists, but musicians in general, who use the F word in their music, and they do so because they think it adds something. It's not just a gratuitous or cheap way of getting a rise out of the audience. They think that it's an important word. It's a very intense word. And if you are feeling very strongly about something, you will find yourself inclined to use the word. People say F that as an emphatic way of saying, I dislike that. Notice the difference in intensity or emotion. So the court is concerned that if they affirm Cohen's conviction, it will only make things worse. States will say, okay, we can ban the F word, the court says, and get away with that. Let's make a list of other words that people find offensive and ban those as well. The N word, for example. The L word. Now that term can apply to different things, but you get my point. There are a lot of words people find offensive. Do we really want to go down the road of allowing states to prohibit and punish the mere utterance, either in writing or orally, of those words? Okay, let's turn now to what the court calls the dual communicative function of language. We're almost done for the day. Okay, I had to check. It looked like my clock was gone, so I had to move my mouse to make sure it's still there. So let's try to finish up in the next 5 or 10 minutes. The court points out a fact of which I'm sure you're aware. On page 26, according to the court, they say, quote, much linguistic expression serves a dual communicative function. It conveys not only ideas capable of relatively precise, detached explication, but otherwise inexpressible emotions as well. In fact, words are often chosen as much for their emotive as for their cognitive force. So the court is pointing out that language is complicated, right? We simultaneously express an idea when we say something, and we also express our emotions. And the F word, according to the court, is like that. When Cohen said F the draft, he was expressing an idea. And that idea could well have been expressed otherwise. Here are some things I came up with. They're all in my lecture notes. Cohen might have written on his jacket, instead of F the draft, down with the draft. I hate the draft. The draft sucks. To hell with the draft. Screw the draft. He could have written any of those things on his jacket, and he would have expressed roughly the same idea that he expressed with F the draft. But let me ask you, do any of those phrases have the same emotional force? Do they pack the same emotional wallop as F the draft? I don't think so. Not even close. I mean, I hate the draft. Big deal. Okay, so I saw a guy today with a jacket on. He said he hates the draft. Well, I don't hate it. Not everybody hates it. Some do, some don't. People are emotional about the draft, and that guy didn't like it. He said he hated it. But when Cohen said F the draft, he chose that word, I think, because of the emotional power of it. Right? He feels intensely about the draft, and maybe in his mind, the only adequate word that captures the intensity is that F word. So if the court said, why didn't you say down with the draft? He would say, because it's not powerful enough. It doesn't capture the intensity of my feeling. Right? I'm really strongly opposed to the draft. I think it's horrible what it does to young men and so forth. So the court is well aware of this, and the court says, if we allow states to forbid certain words, like the F word, how is that not affecting the ideas that are expressed by those words? Right? We would be opening up the door for states to get at ideas by allowing them to ban certain words. We need people to be able to express intense emotions, and the F word is one of those words. So the court is concerned that states might, under the pretext of getting rid of certain bad words or offensive words, they might have as their real goal to squash or quash certain ideas and get them out of circulation. And the court would say that's not acceptable. You cannot ban the expression of ideas. That's content. You're going after the content of the speech under the guise of getting rid of the form of the speech or the particular word that is often used to express the idea. Okay, very quickly, there were 4 dissenting justices. Justice Blackmun, Chief Justice Berger, Justice Black, and Justice White. 3 of the 4 justices, all 4 of the justices would prefer to have sent the case back down for disposition below. In other words, they didn't think the court should hear this case, the Supreme Court. Okay? 4 of them merely wanted to send the case back down. In the hope of at least 3 of them, the hope was that if they sent it back down to the California court system, the California courts would let Cohen go. They would reverse his conviction. Why? Because between the time Cohen was convicted and the time the Supreme Court heard this case, the California Supreme Court had actually had another case in which they interpreted the statute, the very statute that Cohen was convicted under. And the court interpreted that statute as making punishable only willful and malicious conduct that is violent and endangers public safety and order. In other words, the court had given an authoritative interpretation of the statute. The California court did not strike the statute down as unconstitutional. the court simply interpreted this vague statute so that it covers only certain narrowly defined conduct, which I just read to you. The four members of the dissent in the Supreme Court thought that if they sent the case back down to the California courts, they would look at Cohen's case again in light of this new understanding of the California statute. And when they did, they would reverse Cohen's conviction, because clearly he didn't engage in willful and malicious conduct that is violent and endangers public safety and order. Now you may wonder, why would the court want to get rid of it in that way? These four justices did not want the Supreme Court to issue a ruling in this case, because that would set a precedent. And they're worried that this precedent would have bad results down the road. They would rather get rid of this case quietly by remanding it or handing it back to the lower court. Okay, so three of the four justices in dissent wrote the following, or agreed with the following. Cohen's absurd and immature antic was mainly conduct and little speech. The case appears to be well within the sphere of Shaplinsky versus New Hampshire. In other words, three of the justices thought that Cohen's conviction should stand, not because of what he said, but because of what he did. They viewed this case as about conduct, Cohen's behavior, and not Cohen's speech. And they think that his behavior, which is always regulable by the state, could have been prohibited, and was in fact prohibited by the California statute. So they thought that this case is a case of fighting words, and they would have affirmed it for that reason. Okay, Justice White, if you look at my last page, Justice White concurs with Blackmun's second paragraph, the one about remanding the case, and that implies that he does not occur with Justice Blackmun's first paragraph, the one about fighting words. Okay, that's it. That's our discussion. It's time to go. I'm going to get this posted today, as I promised. And when I'm in the classroom tomorrow, having done my lecture already for you to watch as many times as you need, the class time will be put to use in a different way. And it will be a discussion section for those, a session for those of you who choose to come. I don't know how many of you will show up. All of you are welcome to be there. We'll see how it goes. And if you do come, try to have some questions written out so that we can make productive use of our time. And also, you're free to go at any point. If you want to stay for the first 30 minutes of the discussion and then want to go leave, that's fine. You can come and go as you please. Or if you want to come in late, a half hour late, that's fine as well. So make use of as much of that hour and 15 minutes in the classroom as you would like. Okay? So I'm going to turn this off now and get it posted this afternoon, and I'll see some of you tomorrow probably.